Have you already arranged your company succession? No. You are probably not aware that this may limit your business operations. You also risk the liquidation or sale of your life's work. There are various challenges. One of the legal hurdles on the path to company succession is the 10% rule. If your heirs argue in court, a judge must portion out the estate assets into lots. He creates different lots of equal value in order to avoid excessive compensation payments in the division of the estate. The lots should not differ more than 10% in value from a statutory share of the estate. These lots must be assigned to the disagreeing heirs. A family business as the main or most valuable asset often does not fit into any lot. As a result, it is either liquidated or sold. The proceeds are split among the heirs. Learn about your planning options in this video so that you can avoid this result. My name is Tamara Freiner. I am an independent attorney at law in the canton of Zurich. If this video appeals to you, please like and forward it. What is the challenge? An entrepreneur has not yet appointed a successor. He has not transferred the company during his lifetime. Now he dies unexpectedly. His estate includes a family business. The question now arises, who may or should take over the company? The heirs do not agree on the allocation of the company or the division of the estate. There are conflicts of rivalry. An undivided company must be continued in the estate. The principle of unanimity applies. Administration is difficult if no executor has been appointed. A company is a legal entity, an aggregate of rights, a special or related object. The law states that items which by their nature belong together are not separated from one another if an heir objects to such separation. The entrepreneur or testator has not given any instruction concerning the division. What principles apply? The heirs are free to decide on the method of division. The general legal principles of division apply. All heirs have the same right to take over the company, as all heirs are treated equally. The division is generally made in kind to preserve the assets. An estate property may exceed the hereditary share of every heir and may not be split without significant depreciation. An object may be allocated in its entirety to one of the heirs. However, if the heirs are unable to agree on the division or the allocation of an object, it must be sold and the proceeds divided. Liquidation is the last resort, also known as ultima ratio. In the event of a dispute, lots must be formed. The lots are distributed among the heirs by the drawing. The 10% rule for compensation payments applies. According to the case law of the Swiss Federal Tribunal, the judge has no authority to allocate estate assets if the heirs cannot agree on the division of the estate. In the event of a dispute, a drawing of lots procedure must take place. The heir who takes over the company must compensate the co-heirs. The lots may not differ more than 10% in value from an heir's statutory share of the estate. If no amicable settlement is reached, the company must be sold. This makes no economic sense, as jobs are lost. But not only employees as stakeholders, but also suppliers, customers, consultants, and contractors depend on the existence of small and medium-sized enterprises. Therefore, a statutory integral allocation was planned. The government submitted a draft to facilitate business succession in the future. However, the Council of States defeated this bill on March 12, 2024. There is currently no corporate inheritance law. There is therefore currently no safety net for unregulated or unregulatable assets, unregulatable estates with a family business. Are you now ready, willing, and able to act? Would you like to prevent the liquidation of your business? What planning options are available to avoid the application of the 10% rule? As an entrepreneur or testator, you can determine the successor either in a binding inheritance contract or a revocable will. You may allocate your family business to a successor in accordance with a division provision. The 10% rule does not apply. However, compensation payments may be due. Should you wish to privilege the successor, you may also allocate the available quota to him in addition to the company. The obligation to make compensation according to Article 608, Para 2 of the Swiss Civil Code is mitigated. A legacy is also conceivable. It allows for the extradition of the business from the hereditary mass. The successor receives the company directly. The legatee does not belong to the hereditary community. Please note, even with the relaxed statutory share protection, a company succession is not possible today if there is no consensus among the heirs. When drawing lots, equal heaps must be formed. The 10% rule states that the lots may not be more than 10% apart. In addition, the bienésimo négociable doctrine states that they do not have to take on any minority shares in their statutory share. Moreover, the estate division court does not have the authority to allocate estate assets. Therefore, you should start planning your succession today so that you do not sacrifice your life's work. Write the business will after prior consultation. Make a note of the value of your company, the value of your remaining assets. Name your legal heirs. Who should inherit your company? Who has an interest in taking over your business? What should the succession process look like? I look forward to supporting you fulfilling your personal and last wishes to have a peaceful distribution of your assets. Contact me for a consultation. And please follow me on social media, be it YouTube, LinkedIn, or Facebook.